other than the cause of vacancy.
Well, again, we're getting into the semantics of this, and I clearly don't want to adjudicate the matter specifically here either, and I want to rely on your opinion. But I think what's being suggested is we're noting what the definition of vacancy as opposed to the definition of failure to lapse. There's two separate things.
I'm not getting into his semantics, get into mine.
Well, other than that, fine.
Again, it's not a question of semantics, it's just a question of interpretation. Mr. McRitchie's been very thorough, and I understand precisely what he says. I think he understands what I say, and we disagree. If we got 5 more lawyers in here, if each of the candidates brought in their own lawyers, there'd be nuanced opinions. I do understand your question, but I think that the death is what is somewhat irrelevant. I think in 1984, the legislature did not make the same mistake that was made in 53, which was, you recall I mentioned that in 1984, the city council set up an ordinance that said section 58 doesn't apply, and the legislature just struck it. They said, we already have this notwithstanding language, so it's out. But it is interesting, and it's one of the reasons lawyers end up looking like this later in life. Don't continue to look like they started out, but we disagree. But I happen to be the holder now of the office of city solicitor. I think I have a solid opinion. If Mr. Harris disagrees, I would invite the challenge, not in a defiant way, but in a very collegial way. I mean, there were many of us who, in some respects, from the perspective of the operation of government, is better if it's right, because it's an easier outcome. From the taxpayer perspective, it's better if he's right. But from the electorate perspective, it's not better if he's right, because now this body is filling an office that should be filled by the voters, according to the language here, and the minds, I'm sure, of many of the voters and the candidates who believe that they should have a voice where this is a first-year vacancy. So it's a very interesting question, but I respectfully think the answer is pretty clear. But I understand why there's a lack of clarity getting to the end zone.
Thank you, Mr. Timmons.
Thank you. Recognize Councilor Connerton.
Thank you. I have to, just at the outset, wonder what my former colleague from Ward 6 would have said to this discussion tonight. Probably some sort of witty one-liner. But I just, I haven't spoken publicly about Brian's passing, and I just, before we get into this, I'm going to ask you some questions, Jim. I kind of want to wax philosophical a little bit, but don't go anywhere, it won't be long. We didn't really get along too much, too well, but I will miss his one-liners, his witty one-liners, probably the majority of which were directed at me or some sort of policy position that I stood for. The remainder probably were directed at Kevin Coughlin, as we were the target of much of his waxing philosophical. But I'll certainly miss him leaving meetings as we were wrapping up, wheeling his little piece of luggage that he carried his council work in. I developed a Pavlovian response to seeing him in his little wheelie leaving the meeting. I know that it was over, and I get excited that I get to go home.
It's like Red Armback lighting up a cigar.
Exactly. And it'll be sad tonight when we're scheduling committee meetings and I don't see him shaking his head, wheeling his wheelie away. But he'll certainly sorely be missed by this body. So that being said, I'm not going to do a Matt Me impersonation, but I trust any questions he would have had if he would have started with Jim, come on. Tell me how it's going to be. And I've reviewed the letter from Mr. McRitchie, from Attorney McRitchie. I reviewed your opinion, the material you sent us, and then I also reached out to the clerk, and I don't know if he had provided them to you. I suspect he probably did, but I asked for meeting minutes from the 1984 meeting of the council and the 1984 meeting of the council. And I have both those orders that you've referenced tonight. Have you seen those? You have a copy of those?
Yes. Assistant City Clerk Crispo was kind enough to assist me with that.
All right, and so I reviewed those, and you and I thank you for your time on the phone the other day when we went over this as being a lawyer by trade. I'm naturally inquisitive when I get a letter from a lawyer about something that I'm then going to act on. So I appreciate you taking the time and walking through this with me. I just want to ask you a couple of kind of quick questions and then get into the meat of it a little bit. Actually, first, let me ask Clerk Shea. Joe, do we know how much this special election, if approved by this body, will cost the taxpayers, approximately?
It costs, on the low side, 13,000, on the high side, 17 or 18. Some things, it's the personal service cost, police and election workers is much reduced. But certain other things, advertising, etc., cost the same, whether you're advertising for one ward or the whole city. Printing is, of the notice and everything is pretty much the same. So I would settle on 15,000. I hope to keep it at that. It is what it is. It's the bilingual ballot is, which we now have, and we will have, I'm sure, the next millennium, 100 years. I hope it's cost more. What are you going to do? It's probably not 20, but it's more than 13 or 14.
Thank you. And I take my fiduciary obligations to the taxpayers of the city of Quincy very seriously, even when we're talking about amounts in a range of $15,000, and I don't think that that's an expense that or an endeavor of having a special election is something that this body, the city, certainly not this councilor, takes lightly. If there is, as a member of a legislative body, I think we have to follow the rule of law. I think that there has to be some deference given to the councilors who came before us, who sat in this body, sat in this chamber in 2004, 1984, who have debated this as a policy for our city previously. I think that we have to give some deference to them, that while I applaud Mr. Harris's enthusiasm to serve, I think I may disagree with his legal interpretation. Just for the record, note that Mr. Harris is here this evening in the audience with his attorney. I see two other individuals, Mr. Knowles and Mr. Riddell, out there as well. And I hope that should this body support calling for the special election, that he brings that same, Mr. Harris brings that same eagerness to serve to the campaign for the open seat. But let me ask you, Jim, first of all, it was raised by Councilor Finn that Mr. Harris may seek a declaratory judgment or some sort of relief, depending on what this body does tonight. I mean, legally speaking, he could have already sought a declaratory judgment, knowing what your opinion is, right? I mean, we don't necessarily have to set the election. Once we set the election, that gives them a cause of action beyond declaratory relief, but to actually stop the...
Yes, I would call the setting of the election by this body more of a step along the way than a matter of process that needed to be stopped or reacted to.
Right, so it's not that the vote by this body, if we were to set the special election, may be an encouraging step in the process for Mr. Harris to bring his legal claim to court to be decided by a judge, but it's not the triggering event. He could have done that yesterday. He could have done that today. Well, yesterday the holiday, but he could have done that today, correct?
Sure, yes.
No, you also could have done that, correct? You could have sought a declaratory judgment?
Well, not really. I mean, I have the luxury of being the city solicitor, and I'm a little, perhaps overly deferential, but that's because of the mayor I serve. In some communities, the city solicitors issue what they call rulings and say, that's my ruling, and that's how that's how folks have to act. And when you read the charter, it somewhat leaves it a bit open. But I would not, in a situation like this, file a declaratory judgment. Because if I were to do it, I'd be inviting all kinds of, I would say, responses by others who, you're probably familiar about others would be the term mandamus. It's almost an application of my responsibility. I've analyzed it, made a decision, and given advice. I don't need to go to a court and ask for a third-party opinion. And that's not arrogance or anything. I'm just saying that's my role. I've performed the function, and now if a party disagrees, they can seek declaratory relief. So technically you're correct, but I would say no, that's not a proper way for me to perform my job.
Thank you for that explanation. Now let me ask you, what is the legal requirement, if you know, of this body to call for the special election? Me as a city council, what's my legal obligation to call for a special election? Hypothetical, what if this body doesn't want to do it? What if we say no? What if we just, someone objects, thing goes on to another agenda, it doesn't happen, for whatever reason it gets kicked down the road? I mean, I think that's unfair to the residents of Ward 6, but I'm just, in a hypothetical sense, what's our legal obligation to actually set the date?
Well, the way the special act's written, the Act of 2004, the language says, shall forthwith call a special election. So it's not discretionary, it's not a matter, it's a mandate that you forthwith call a special election. There is now a vacancy. Ward 6 requires representation. The citizens of Ward 6 require representation. So it's incumbent on this body, under the provisions of this special act, to forthwith call a special election, and I would call that a mandate.
And there's no specific time frame from the date of the vacancy to the calling of the election?
Correct. It says forthwith, which means you should act in due haste. And I know that the city clerk, the assistant city clerk, and I have talked on several occasions about timing and everything. And the city clerk has made an earnest effort, I would say, by the first meeting after an election cycle, getting the matter before the body. So that meets the mandate of forthwith, I would say.
That's if we were to pass it tonight, if we were to vote in favor of it tonight. But if we weren't, if we were to delay, would you suggest that that would be this body not acting forthwith?
Correct.
So then essentially it's your legal opinion that the body not only has the legal authorization to call for the special election, but we also must call for the special election.
Well, I'm saying the language here says shall forthwith call a special election.
Two legal opinions that we can call a special election, and that's the appropriate next step to fill the vacancy. Right? Your interpretation of the law is that to fill the vacancy, we need to call for a special election. And then your interpretation of forthwith, the time frame to call that special election is tonight. So that's, you're not giving us a lot of room. I'm not complaining about it. I'm just, for the record, that's, we have to call for the election, the special election this evening. That's your legal opinion as the city solicitor.
Right, that's a different question than has ever been proffered to me, and we're in a little different part of the act. But yeah, the last phrase is shall forthwith call a special election.
Now, this is something separate and apart from what we're facing tonight. This is an issue or a policy that this body could attempt to effect change of, right? If this body, the 8 folks sitting up here, if we decided that it makes more sense to appoint the runner-up given any vacancy, we could do that, correct? Not tonight going backward, but we could do that either through a home rule petition, right?
Right, I don't think it would apply to the current Ward 6 vacancy, but you could go back, someone could bring forth a new proposed home rule petition And you could go through the process of trying to get that passed, and I would be available, I would say, when the next